It's part of the whole thing with the lighthouse. All that, I think, is excluded.
Okay. Next is my understanding.
Hold on, he's got something he wants to interject on the Roth, I think.
Yeah, just for clarification, though, yeah, obviously the report's out, the court made that very clear, but the testimony is still there, so I intend to comment on the testimony of that.
Any objection with that?
Yes, because as we mentioned, we can't get in the lighthouse, so how's it getting on the report?
Well, wasn't the report's of value to you?
What's that, Your Honor?
Wasn't the report's value to you?
Circumstantial evidence, Your Honor, as to intent and causation. He's the only one doing this in the entire hospital system.
It gets back into it. It was part of that whole process at the end. Sorry, Mr. Zion, what's good for the goose is good for the gander. I locked it all out, so you're out.
So not only is the report out, all of the testimony about Dr. Swanner and Dr. Roth is now being excluded before closing argument. Is that your ruling today, Judge?
Well, if it's the pre-events going up, like I said the other day, going up to the actual investigation by your office and the police, I think all that's fair game. Anything else after that, I don't think is fair.
All right, well, Dr. Swanner was testified that he saw a report that couldn't be located, that verified he was the only one doing it. That's when he realized he had a problem. Dr. Roth, later on at the request, like in 2020, like a year and a half afterwards, that wasn't part of Lighthouse. That report was produced at the request of the defense. So, I mean, that's why I thought, you said the report's out because it was cumulative, not because it wasn't relevant. You said the report was cumulative, so the report itself is out, but the testimony stands. Are you now changing that ruling in regards to Dr. Roth? Because that was not part of Lighthouse. That was produced as Ms. Menashe subpoenaed that information.
Good.
I thought, my understanding is that there were significant issues with that testimony, both from Roth and Swanner.
Well, my response is very simple. Most of that was done after the fact. It goes into the lighthouse, so no, can't be raised.
Now, I understand the court's ruling in terms of Project Lighthouse, but when the court refers to after the fact, you are referring to after indictment. Is that correct? Absent Project Lighthouse. Lighthouse aside, everything up until indictment is okay because of the investigation by law enforcement and
As to the nature of the investigation, it is fair comment.
Okay. So I just wanted to make sure because where the line was on that. So.
Well, the lighthouse is a post-remedial action taken by the hospital to control the media. It has no relevance to the case. Okay? We went through a lot of it. You tried to tie it in, never got in. Okay? So that's my ruling.
Okay. And then I have, my understanding is the Tracy Young records cannot be referred to. However, the testimony can. Is that correct?
No, that was not my thing. Tracy Young was deemed irrelevant. We objected to everything regarding Tracy Young. He said that's not, they didn't tie it in. They had no one testify about it directly that was there.
It's a specific act. Tracy Young is out.
I'm sorry to hear that.
It's out.
I just want to clarify something. There's the issue now of a deficiency in the investigation because they did not, after having received it, did not do anything with that. I think that's a significant issue with that. However, there are the separate Tracy Young issues with Project Lighthouse, such as the reports and things like that, and what the hospital did with that. I'd like to still be able to discuss the investigative part and the deficiencies thereof as it related to her.
Judge, they had the opportunity, decision not to bring in, they had the nurse who was at bedside with Tracy Young. They decided not to bring that in. They didn't bring anybody else in that was there. They had everyone subpoenaed. They made the decision not to bring anybody in that would have had either firsthand knowledge of what happened with Tracy Young or they didn't put on anybody that had a full review of those records. So the court made it very clear Tracy Young is out.
That's not entirely accurate. They objected to us bringing up issues with Tracy Young as it related to our case in chief. However, there's still the detective's testimony and his lack of action as it related to Tracy Young. And I think that's, and then, you have that whole portion of his testimony as it relates to that. And I think that goes to the investigation. I can understand I understand clearly the court's ruling on Lighthouse and how her name came up multiple times through that. And that cut out a lot of what I was going to say about her, but there's only so much I can say in reference to the detective anyway.
Well, if the detective was the one who brought it up, or it was brought up through his testimony, I'll permit that.
Okay.
Your Honor, for the record, the only thing he said was we were not provided with a patient by the name of Tracy Young.
That's not all he said. He was
See,
aware.
I remember something different with that. I thought that he talked about Tracy Young for a minute.
We did. And I've since reviewed it. I am quite certain he also was aware that it was Dr. Husel who brought it up to his civil counsel. He's also aware of several other facts as well. And Dr. Schweiger also had Tracy Young's medical records as well.
But you don't want Dr. Schweigert's in anyway.
No, but he testified about Tracy Young. That's the only.
As to the detective fine, Schweigert I have my problems with.
Okay.
And state's position? You guys,
May I address Dr.
Yeah, go ahead.
Schweiger, since I handled that examination? Dr. Schweiger had a few records supplied by civil plaintiffs' counsel at the civil deposition about Tracy Young. He opined at the civil deposition about a couple things, and then answered to Ms. Menashe's cross about that exchange at the civil deposition. What I think is germane for our evaluation here is that he never fully examined the entire record. He was told some things by civil counsel, looked at a couple of documents, which he did not quantify, and then did discuss the fact that she was not opiate naive, quite the contrary. So there was never a fulsome review of her records by any witness in this case, certainly not Dr. Schweiger, and the cross-examination was kind of a sideswipe cross-examination about it, certainly not enough to warrant a discussion about Tracy Young at this point in the case, because there's not enough evidence in the record to give it its due.
as what Schweiger testified, you can go into it.
Okay. And the last thing is, I wanted some clarification on the doctors for Mount Carmel. I'd like to be able to express that they're not experts in this case and that their testimony shouldn't be considered as such.
That would follow what I had. They were subjective witnesses.
Correct.
You know, even though they had qualifications, they are still to be treated as such. Their testimony was treated as such throughout. They weren't giving objective opinions such as the three doctors, so you can go into it that way.
Perfect. And any references to, I'm going to do this, and I'm sure the state will do it as well, but any references to the testimony, I'm going to preface with the court reporters, the official transcript, there to rely on their memory, and the official record only, that anything I say about the record and what was testified to is for argument purposes only.
Okay. One of the things that concerns me is, in mentioning transcripts, they'll want copies of transcripts, and it just takes too long to produce them. So be careful in going through that, because the first question we'll get is, we want a transcript of Dr. So-and-so's testimony. And it's like you have to remember on your collective memory.
I'll refer to it as testimony, not transcript.
Okay, fair enough. Anything else before I get into my issues?
Just so I'm clear, Judge, you have a copy, they have a copy of my PowerPoint. There is a slide with a picture of Dr. Swanner and Dr. Roth as they appeared in this courtroom and testified. Where was administration? The next slide is administration realizes they have a serious problem. Only doctor in the entire Mount Carmel, et cetera, et cetera. You have that slide, Judge. Is that out now, you're saying?
No, just like I told him, you can get into the investigation up until you guys are involved.
Well, Dr. Roth's investigation was not part of, what he did for that was not part of Lighthouse. That was in response to a subpoena from the defense. And you said the report itself, you said it was relevant, but the report itself was out because it was cumulative. So Dr. Roth can still be part of that even though that was in 2020, that he investigated that part of it. So that's well after.
It's well after, again, it's out.
It's out. Okay, so let me change this. Judge, and I will, we also would like a final copy of the jury instructions before we begin, Judge. I'm going to put a record on that slide. And Dr. Roth's picture.
You may. There's your copy, if you'd be kind enough to take this copy to defense counsel. Okay, anything else from the lawyers at this point in time? I've got two issues I have to discuss with you. One of our jurors sent a text to Ms. Schaefer this weekend. Clearly, he had been paying attention to the news. He's currently isolated in the back, okay? He was questioning about the events of last week. He threw in several terms of art that were concerning. I've got him isolated. Clearly, he was paying attention to the media with his questions, okay? I think I need to excuse him. He is one of the 12, but clearly he was less than complimentary towards parts of the case. And I had some concerns. I didn't want him tainting any other jurors, so he was immediately separated upon his arrival, and he's currently back in the judge's office. Any comments on it?
Can we approach to figure out who we're talking about here, Judge?
Sure. David, just chill.
By the way,
Go out there and entertain the gallery so they can't pay attention, David. Thank you. also,
I need to change this.
he'll sit for a minute until you get back to him with the computer.
So this is an added text box.
He worked on it. It works with David's machine. It's currently set on David's machine. It's not set.
They were saying they couldn't hear the audio back there. And there was no, so maybe
Start at jazz then.
I will have her log into that for the rest of the week. I will see if she's done.
Why don't you get Mr. Gale's out? Mr. Gale's out. Let's put the Odgers get in here first and dismiss them.
Your Honor, we have an issue, if we could grab David.
David, what do we have an issue with?
May we approach again?
Sure.
I did say, is this a prop?
I thought Sanders did.
Oh, Dave?
Yeah.
paper.
Sure. Is it there? I don't know where it is. It disappeared. I think it does.
Simulated somewhere.
I just I haven't seen it since last week, so. Do you know what happened to the stapler?
Oh, it's on our table.
Never mind. Got it. Thank you. I'll put it back on my desk if you need. Did you take care of
All right. Oh, relax. Relax, everybody. Council, I don't need it on the record. Come on up. No. Yeah, often it's already been sworn in. You got two of them now.
Judge, you want to test this? I had to unplug it to do some edits, so.
Oh, you tested my luck on it. There you are.
All right, thank you, sir.
Are you guys using the PowerPoint?
Yes, sir.
Okay, during the break, because I imagine we'll break after he finishes his, we'll test it.
We have some things to talk about that we provided that this morning. We gave them our copy this morning. They emailed it to us. We have some things to talk about that with them to the judge.
Okay.
Want to talk about them now?
Now I want to get a jury here and get going. All due respect, but they've been on ice for a while now.
Understood.
Okay, competition. Need to make a copy of the email and text. Okay. Well,
Can you demand included in it?
it doesn't matter. We'll call it Court Exhibit 14. Is that okay? I think we're at 14.
Hold on. Sam, I don't know. Okay.
Mr.
Well,
Lapidus.
go
thinks it's
15 to be
17.
safe. Huh?
Mr. Lapidus thinks it's 17.
17? Fair enough. Distraction. Did I tell you I got in a car accident Friday?
All rise. Thank you. Please be seated.
Good morning, ladies and gentlemen of the jury. We're now entering the final phase of the trial. It's the closing arguments and the charge given by the court. Can you all hear me okay? Yes. Okay. Before we get into it, I want to take a second. I want to thank you all. You guys have been wonderful throughout this trial. I do appreciate it. I'm proud of each and every one of you. You worked hard for me, and I just want to give you my thanks. I know it can be tough at times, but thank you very much. The closing arguments are what the lawyers feel the evidence has shown. It's not evidence itself. Let's aid and assist you in your deliberations. After we get done with the closing arguments, then I will give the charge. Now, the state has the burden of proof, so they get to give the first argument, and then they're entitled to what we call rebuttal in response to the defense. So we have those three phases to go through before we get into the charge. Okay? With that, Mr. Zion, you ready to proceed?
Judge Holbrook, co-counsel, defense counsel, Mr. Husel, members of the jury. Let me begin, as the judge did, by thanking all of you for your service and for the attention that you have given the testimony and the evidence in this case. I know defense counsel would agree with me when I say we've done a good job picking a jury when we can get 12 plus people from our community that paid as close attention to the evidence as you have in this case. So I want to thank you all for that. Let me begin also by apologizing in advance for anything that I say during my closing or my rebuttal, which is not how you remember the evidence. Sometimes when you're with a case for a while, and I've been with this case for a while, you think evidence comes out in a certain way or said, and that would be in my argument. If it's not how you as a group remember the evidence, please don't think I'm trying to trick you or pull the wool over your eyes. What's important is how you remember the evidence. What was the evidence? What did the state of Ohio have to prove before you can find the defendant guilty of murder as charged in counts 1 through 14 of the indictment? Well, as the judge will tell you later this morning, murder in the state of Ohio is very straightforward. That's it. That's the entirety of the murder statute as defendant stands charged. You must find beyond a reasonable doubt each one of these elements: that he purposely caused the death of another. Venue means that it happened here in Franklin County. Is the Franklin County Court of Common Pleas the appropriate place to hear the case? And identification. Is the defendant the one that is responsible for this? Purpose. The judge will tell you, the law of Ohio says, a person acts purposely when it is his specific intention to cause a certain result. It must be established in this case that in the time in question, there was present in the mind of the defendant a specific intention to cause the death of another. So if you want to figure out, like, what do they mean by purpose, it's like, what did he intend to do when he administered these doses of these medications to these patients under these circumstances? What was his intention? What was his purpose? So this is a very good point, a very important point that I point out to you, as the judge will tell you. The purpose with which a person does an act is known only to himself. You've got to get in his mind. You've got to see what his intention was when he was doing this. And unless he said it to people at the time he's doing this, you have to figure it out from all the facts and circumstances surrounding these deaths. A person is presumed to intend the natural and reasonable and probable consequences of their voluntary acts. That's also part of the definition of purpose that the judge will give you. And what I would emphasize here, and what I will say again and again, you are here instead of professional lawyers and jurists and law professors. You're here as members of our community in Franklin County because we are relying on your reasonableness and your common sense. You'll see that word over and over again, reasonable. Once again, you've got to look at all the circumstances when you're trying to figure out what a person does something for. What is their intention? Circumstances. And this is why we spend so much time on circumstantial evidence in voir dire. Remember that silly little example of the cherry pie? That's what we're talking about here. So if someone tries to argue, oh, it's just all circumstantial. Oh, what do they got? It's just circumstances. Well, circumstances can sometimes be very powerful. As I would argue to you, they are here. Circumstantial evidence is proof of facts by direct evidence, which you may infer other and related facts that naturally and logically follow. Naturally, logic, common sense. That's what this is about, folks. Based on the common experiences we all have. And furthermore, just because it's all circumstantial, in the law, direct evidence and circumstantial evidence are of equal weight. What weight you give any particular piece of evidence is up to you as a group to decide what it's worth. But just because something is circumstantial doesn't mean it's not as good as direct evidence under the eyes of the law. So we don't only have to prove that it was his purpose, his specific intention to cause these victims' deaths when he gave these doses during these palliative extubations. We have to show that those doses, in fact, caused their deaths. Causation. Cause is an act which in the natural and continuous sequence directly produces that death, and without which it would not have occurred. Now that would seem to be a problem for the state of Ohio because, candidly, these people were very critically ill. They were in the ICU for a reason. So you might be asking yourselves, well, how do we know it was just the medicine, just the 1,000 micrograms of fentanyl combined with the 10 milligrams of midazolam he gave them all at once that caused their death, and not other underlying diseases? Well, the judge will tell you this is part of causation. This is part of the law. This is part of what you must consider in determining whether we've proven causation to you. There can be more than one cause for an event. And if the defendant's actions is one of those causes, it's it's not a defense that something else would have killed him too. This is the example that is sometimes given to law students, I would argue to you, about a person that jumps off a building, and it's the height that they are, without a doubt, going to die when they hit the ground. When they hit the ground, they are going to be dead in seconds, as soon as they are at ground level. And a person in that building has a gun, and as that person falls past them, they shoot them. They shoot them right in the head and cause their death at the moment they hit there. 2 causes of death. But for the bullet, they wouldn't have died, but for hitting the ground, they wouldn't have died. 2 causes of death. It's not a defense to say they were about to die anyways. I just killed a dying man. It's not a defense to say they're going to be dead in a few seconds, a few minutes, a few moments anyways. I just hastened their death by my actions. That's what that instruction means. So when you heard the expert witnesses in this case, Dr. Ely and Dr. Schweiger, say that he either caused or hastened their death, that's what that instruction of law is telling you. If you hasten a person's death, even if their death is as sure as the sun is going to rise in the morning, if you hasten that along, you have caused their death under the eyes of the law. So what are we talking about here? Well, we're talking about the fentanyl. We're talking about these doses of fentanyl that the defendant gave, ordered to be given, prescribed to these victims. This is the cause of their death, folks. Even though they were very critically ill, and perhaps some of them were on a trajectory to die very soon anyways, you cannot hasten their death. You cannot quickly, painlessly cause the death of a dying person. You can't do it. Not in the state of Ohio. State's Exhibit 28B. That's what this is about, folks. Death of another. The fact that there were 14 people who died here will not be in dispute. I've got to prove each and every element of murder purposely caused death of another. It happened here in Franklin County, and he's the one that caused it, that he's the one responsible for it. The fact that these 14 people died will not be in dispute. Those are 14 people whose death he either directly caused or hastened at the nighttime ICU when he ordered the doses of fentanyl and benzodiazepine. Don't forget about the benzodiazepines in this case during those palliative extubations. I've got to prove everything. The fact that Mount Carmel West, that all of these deaths occurred in Mount Carmel West, which is here in Franklin County, or was here in Franklin County, not in dispute. And that he's the one that's responsible for this. Sometimes, folks, that's the whole thing in a case. Everyone agrees a murder occurred. Everyone agrees that it shouldn't have happened. And the question is, who did it? Well, in this case, that's not the issue. I've got to prove it was him, but that's not the issue. They've stipulated he is the doctor prescribing these medications. So, a fair question. You may be asking yourselves, was it really his purpose to cause the death of these patients? And he's writing it down, putting it in the medical record. It's being reviewed by pharmacy. It's right there. So the question is, where's pharmacy? Why is it pharmacy calling him on this, saying, you can't give this much medicine to these people? You're doing what? Where's pharmacy? It's a fair question. Well, as you heard from each one of these men, Taylor Schroyer, Brent Dreschbaugh, Randy Mile, John O'Connell, pharmacy was unaware. Because of the system that was in place at the time, at the nighttime ICU at Mount Carmel West, pharmacy was unaware of what he was doing. Completely unaware when Dr. Husel ordered these medications and the nurse, as was their habit, as was their training on the job at the nighttime ICU, you don't need to wait, just go hit that override button on the screen, just boom, real quick and easy, let's get it done. Hit the override button. Pharmacy gets a notification after the fact, that retrospective review. What did Talon tell you? Talon told you, I was trained that, it's already done. I mean, what's the point? What's the point of calling up to question a dose of medication for anything that's already been given to the patient? What's the point of, my point is, when something comes to me to review, is the patient allergic? Is the dose right? Is this medicine correct? Et cetera, et cetera. When it's already done, why would I go through that process? It's already in the patient. So his training was just hit verify, just clear it out, just clear it off like junk email, just get rid of it. Overrides. I mean, this Menashe made a point, oh my goodness, how many things were overwritten? Thousands and thousands of things. They overrode everything, including these medications during the palliative extubation. So whenever any of that medication was pulled to override, pharmacy is unaware. And remember, I kept saying nighttime ICU, and I think maybe there was some eye rolling whenever I said that, but that's important here because there's just 2 pharmacists for the whole hospital. Skeleton crew, less resources. After 11 o'clock, it's just, in many cases, Greg and Taylor down there on the first floor. They're not just the pharmacists for the ICU. They're the pharmacists for any surgeries that are going on. They're the pharmacists for the emergency room. Anything comes into the emergency room. They're the pharmacists for all of the patients' floors. 2 pharmacists for the whole hospital. And they're not going through these medication orders that are already done. The ones that were done on override, administered, we get a note, done, verified, move on. Other things to do. When they did get a chance to prospectively review, and remember Talon told you, 1,000 micro, what? About 6 months before this all happened, before he finally told Randy about it, he called Dr. Husel. Did you add an extra 0? No, it's for a procedure. Okay. You know who am I? I'm a nighttime pharmacist. I have 2 years experience. He told me it wasn't a mistake. It wasn't an extra 0. I think that is very telling. I argue to you that is very telling that this pharmacist with 2 years experience sees 1,000 microgram dose in the ICU. And it's like, there's got it. It's an extra 0. That's 10 times what you give a patient. Nope, it's for a procedure. Nope. Okay. In October, though, October 24th of 2018, he finds out what that procedure is. That was his testimony. And he thinks, but not really getting 1,000 micrograms of fentanyl to a human being in the ICU. You're not really doing it. It's not stealing. I mean, that's not medicine. It's not medicine to get that much of that drug to an individual in the ICU. They've got to be stealing it. That was his concern. Someone's up there stealing these meds. But if it really is for a palliative extubation, if they really are putting that much into a person, what were his words? Wildly excessive. Wildly excessive. And that's a young pharmacist with 24 months on, and he knows that is not appropriate. And he tells Randy Miles about it. Pharmacy was unaware until October of 2018. Now the radar's up. Now the experienced guy, Greg Dreschwald's in there. Read his emails. You'll have this. States Exhibit 20A. Their radar is up. Randy, as you know, there have been a few instances of highly questionable, quote-unquote, palliative withdrawal orders by Dr. Husel in the ICU. Unfortunately, I have a new one to bring to your attention. Read that email. Greg knows this isn't medicine. Greg Dreschbach knows this isn't appropriate. Read what he says in there. And how does he end that? I don't want to make any assumptions or accusations regarding what might be going on in the ICU, but it's worth noting some of the same nurses are routinely involved when these circumstances occur. November 19th, 2 days later, States Exhibit 20B. Well, here we go again. This time it occurred on evening shift, meaning that's after the 9, a pharmacist on the floor till 9 and then 11. He stumbled across this. What happened when we received the 2 full credits? He wasn't even the pharmacist on this one. This was Greg White. And he happened to stumble upon it, because remember, these are being pulled on override. They're unaware. Their radar's up since they found out what's actually, they're saying the procedure is in the nighttime ICU. And he talks about the circumstances of Melissa Penix. Read that email. Obviously, there's great concern for the doses that were ordered and given, especially in the context of a patient who was able to report her pain just prior to administering such large doses of these very dangerous drugs. He's actually looking at the pain score going, well, she's reporting pain, not realizing she's comatose. It is also concerning that the nurse removed the med 15 minutes before the orders were even entered. Pharmacy was unaware until. In pharmacy, Halen Schroyer and Greg Dreschbach are the ones that bring it to the administration's attention. Pharmacy is the one that unearthed what was going on. Where was administration? Well, you heard from Dr. Swanner, pharmacist by training way back. That's what he went to school for originally. He was a pharmacy for a couple of years. And then was a family practitioner for most of his career until he got into the administration. He doesn't know what's going on. He doesn't know if there's some new procedure. He doesn't know if there's some special circumstances. He knows he needs to investigate this. They missed it in October because that voice report, peer review, didn't meet. What happened? They just didn't meet scheduling problems. But when it happens 2 more times and Greg sends those emails, now they know they have a serious problem. He realized in his investigation, talking to the other ICU doctors, remember he told you I talked to Dr. Lawson, I talked to Dr. Dominic, who's head of anesthesiology. I talked to, is there something new?
Whoa. Off. Take it off. Go ahead.
And he testified to that, exactly. Can I put the slide up, Judge? We talked about this specifically before everybody else.
I prefer not, no. Go on to the next one.
May I talk about his testimony?
You can talk about his
His
testimony.
testimony was that he was the only doctor in the entire ICU and the entire hospital chain.
Okay. I need to talk to these guys. Relax for a second, ladies and gentlemen. David? Hold on. You ready, Sam?
Yes, sir.
Okay, you may proceed.
What did Dr. Swanner tell you regarding administration? Unaware and realizing they had a big problem in the fall of 2018. Dr. Swanner told you he was made aware of the fact he's the only one doing this outside of the operating room, outside of somebody on a ventilator. Only one giving 500 micrograms and above. We're not even talking about 1,000 or 2,000 micrograms. This is 500 micrograms and above. And we're not even talking about the has that dose outside of the OR and on the ventilators. That was his understanding. And that just wasn't in the ICU in Mount Carmel West or the ICU at the other 3 hospitals that were in the system. That was throughout the entire system, outside of the OR, patient not on a ventilator. At that moment, he knew we had a serious problem. Remember, what did Dr. Swanner tell you about having an attending in the nighttime ICU? This is a new concept. Up until 2013, they only had these student doctors, and these residents, these caretakers, so to speak, who were there learning how to be doctors. To have a fully qualified doctor on their own, running everything in the nighttime ICU in 2013 is a new concept in ICU care. And Mount Carmel, wanting to be part of that new standard, hires 2 doctors to cover the nighttime shift. They hired the defendant, and they hired Dr. Haggis. Haggis was hired first by a few months in 2013. But remember, he had several more years' experience and was board certified in internal medicine. Well, his testimony was, he had been a doctor since 2009 out there in the world at other hospitals. The defendant was a brand new doctor. He's so new, he's not even boarded yet. And Dr. Swanner explained that's not unusual. It's a requirement that you're board certified in your area. But he's so new, he actually needs some experience before he's even allowed to sit for the boards. So he's not even board certified yet. And he's completely on his own there. It's not like he has those years of experience that he can rely on when he starts off with other doctors around him telling him, this is how you do this is how you do that. He's a brand new minted doctor. There's no evidence. Remember the testimony of Dr. Swanner, Dr. Haggis, Dr. Moody, Dr. Ralston. Never asked us about anything procedurally. Talked to Haggis sometimes about scheduling. Never consulted them about anything that he was doing. He's in his own bubble, folks. I would call this, I would argue to you, he's in his own echo chamber in the nighttime ICU, dealing with other new people that he is training on his methods that no one else in the entire Mount Carmel system is doing. That I would argue, based on the testimony of Dr. Schweiger and Dr. Ely, that no one else in the world is doing. It's just not done. And there's no literature, like Dr. Schweiger and Dr. Ely told you, to support what he's doing. Where are the attending and discharge doctors? Right? You have the medical records right there, states 1 through 14, and I am going to ask you to look through them. There's a lot there. Look through those medical records. The discharge summaries are written by the attendings. And all they have to do is flip to the back and see what the drugs are that he's administering during these palliative extubations to know what he's doing. So where are they? Why aren't they flipping to the back page of those medical records, or they don't actually print stuff off anymore, it's all on a computer screen. But why aren't they just going to the medication administration records and seeing what's going on? During the palliative extubation, everyone to a person told you, you didn't do that. You don't do that. I mean, some of these folks up here, they were the attending, hadn't even met these patients yet. Some of these folks up here weren't even actually the assigned doctor. Which one was it? Was it Dr. Varghese, who was actually covering, as like almost like a matter of duty or for Dr. Thurston? Because Dr. Varghese had been assigned it, but Dr. Thurston had been the one that actually did the history of physical. It should have, the computer system should have sent the duty, doing the discharge summary to him, but she was the assigned person, so it wasn't even her. It's a cut and paste job, folks. It's a form, it's a template that comes up. And she does it because, well, if you don't do it right, within a certain number of days, your practice gets dinged for not, getting things done in a timely manner. Why is it important to get the discharge summary and the death certificate signed? Because the body can't get out of the hospital, the body can't go to the funeral, you can't bury the body. So those duty tasks, those duty matters are taken care of. Not one of them is doing a deep dive into any of these medical records. They are cutting and pasting the last progress note and signing forms. They are assuming good intentions. Not one of them were aware of the medications and/or doses the defendant had administered to the victims at the time of palliative extubations. They weren't aware of it when they wrote those discharge summaries. They were not aware of it when they signed those death certificates. Where are the other ICU doctors? You heard from 3 of them. Dr. Hager split the nighttime shift with him, Dr. Ralston, the director, and then Dr. Mooney, the co-director. They worked during the day. If they did pick up a night shift, it was because either Dr. Hagris or Dr. Ralston, Dr. Hagris or the defendant were not available. So it's not like they would work with them at night. If they did it, they would work on their own. What did they tell you? They have never, ever given equal analgesic doses of pain medications and benzodiazepines anywhere near the dose in the ICU that the defendant was giving the victims during palliative withdrawals in the nighttime at Mount Carmel West. They called Dr. Ralston. You mean during palliative extubations? No, I mean ever. I don't use fentanyl, I use morphine. But remember what he said, an equal analgesic dose of morphine to 1,000 micrograms of fentanyl is 100 milligrams. Have you ever filled up a vial of 100 milligrams of morphine and given it to any one of your patients in your 30 plus years, 20 plus years, however long you've been a doctor? And stuck it into them, not 90? Nope. 80? Nope. What was the most he ever said he gave? 10 to 15, and that's a divided dose. That's as needed. Start off with 10 to 15, of course, which would be the equal analgesic dose of 100 to 150 micrograms of fentanyl. It's just not done. What were they doing during palliative extubations? Generally, they start with 2 to 10 milligrams of morphine, which, as they told you, and as everyone else that testified that knew of this told you, is equal to 20 to 100 micrograms of fentanyl. And if needed, if indicated, remember they're testing, if indicated, it's not like an automatic thing. If I think they also have some anxiety, I will also start with 1 to 2 milligrams of a benzodiazepine. And then you judiciously titrate as needed. Titration, that idea is that you start low and you go slow. Because remember, Dr. Ely, you're trying to cover the pain. No one is about people suffering during the death. No one is about, the redemptive quality of pain. No, it's about covering the pain. You did that with you need enough to cover the pain, to mask the anxiety, so that you get the benefit and not the harm, because these are dangerous drugs. And it's so easy to go from the harm being much greater than the benefit they are receiving. You titrate. There's no reason why you can't add more later. They are all about providing, controlling pain and providing comfort. Okay? Well, certainly though, you've had trouble with it. No, never any issues at all. Never any issues when you start like this You watch your patient, you listen to what's going on with them, you're at bedside, you're listening to the family, you never have that. He told you specifically, you use the small frequent doses every 15 to 30 minutes, if indicated. So what are your factors, doctor, for dosing decisions for palliative extubation? What if someone's brain's damaged? And several of the 1 through 14 victims in this case had brain damage. What if they're brain damaged? What if they have evidence of an anoxic brain injury? Do you give them more medicine or do you give them less medicine? Well, you give them less medicine because when you're brain damaged, especially the upper part of your brain, you can't feel that anymore. Your body loses the ability to perceive pain. So you either give less or you don't give any. They don't need any pain medication. That's corroborated by Dr. Schweiger and Dr. Lee. Both told you that. That's just not a Dr. Ralston thing. Age. Well, if they're a young man versus an old man, how does that factor in? Well, you've got to reduce the doses as the person gets older. Your body, as you reach age, as you reach these milestones in your age, you become elderly. You cannot handle these doses as well. Your liver doesn't work as well. Your kidneys don't work as well. So the older you are, you've got to cut it back. Because once again, the goal is to control the pain, is to mask the pain. But not to give them so much that you're causing them harm. Even if they're dying, they still have value. Right? Even if they're going to be dead, you just don't say, well, hell, just get it. No. You still need to do that as a doctor. Just enough so that you're covering that pain, you're masking that anxiety, but not so much that you're causing them harm. You look at their liver and kidney function. If they have a compromised organ system, and remember how important the liver is in dysfunction of processing these drugs and getting rid of the toxins that they produce. And so if your liver's not working as well, as many of our patients, many of our victims, their livers were not working as well as they could have been, you cut it back. If they are needing dialysis, that means their kidneys are not working. You cut it back. You mask their pain, you control their pain, but you don't want to hurt them. Dr. Ralston said, well, and then I looked at the patient. For him, his practice is not to let a nurse go in and write whatever number. His practice, during the most important things doctors can do, when there are people in their care, be with them when they die. He's with them when they die. And I look at them. And if they're in pain, that's me. Nothing more. He's there at bedside as they die. The family's there. That's another thing he said. They know better than I ever will. What do you guys think? Do we need more? He's asking them. Because it's not about people dying in pain and anxiety and fear. It's about controlling that pain. It's about controlling that anxiety, but not killing them. First day of the practice, Dr. Moody's, she said I'd start anywhere between 4 to 10 milligrams of morphine. 10 would be about the most I'd get. And then PRN, you'll see that quite a bit. PRN, remember that stands for, I don't know what it stands for, but it means as needed. Whenever you see as needed, that's an ongoing instruction to those that are caring for them. If they need this, just go ahead and give it to them. 2 to 4 milligrams, up to an additional 10 milligrams of morphine. She doesn't use the benzodiazepine of midazolam versus she uses Ativan. And she would typically start with 2 milligrams. And once again, remember her testimony. Only if it's needed. It's not an automatic thing. Dr. Hagris. I followed the order set. I followed the order set. Did you have any problems? Nope. You'll see the order set. There's several that were in effect in the time period in the indictment. 17B. Just clicking boxes for the nurses. You start here, and as needed, give them more. Look at these doses. 2 milligrams. 4 milligrams. It goes up to 10 milligrams. Fentanyl is not on here, but you do know the equal analgesic dose of fentanyl. Times it times 10. Nowhere near. what the defendant is doing in the nighttime at the ICU during palliative extubations. He never talked to anybody. He never said to anybody, ladies and gentlemen, and I'm talking about while he's working there. Never went and consulted with him. Never went and said, what do you guys do? This is what I do, what do you think? And the point of this, ladies and gentlemen, every time you heard the question, well, isn't it true that equally trained doctors with equal experience can say, you need to do this, and then you go get a second opinion, and an equally trained and equally experienced doctor would say, no, you need to do this, you know, give him a second opinion type thing. He is not equally experienced as these other doctors. Not nowhere close. When you're talking about Dr. Ralston, or when you're talking about the experts, Dr. Ely or Dr. Schweiger. Nowhere near them. Not equally experienced. Not equally trained. He's not even board certified at this point. Where are the nurses? Once again, pharmacy has a record. Administration has a record. The attendings, all they got to do is flip to the back. Well, these are the folks at bedside. These are the folks that are actually putting this medication into these victims. They have training. And as you heard over and over again, they don't answer to the doctor. They can refuse any order that they believe is harmful to a patient. In fact, they're obligated to do that. They answer to their chain of command, the charge nurse, the administrative nurse. But once again, it's the nighttime and the ICU at Mount Carmel. And how many? The director? Oh yeah, we always had a director or nurse somewhere. On the floor? Oh, no, for the whole hospital. It's a skeleton crew at night. So there is someone they can go and talk to about this, but it's not like they're at the nurse's station. Their chain of command is somewhere in the hospital, and it's one person in the nighttime. Skeleton crew, less resources. One of the circumstances you can consider in how all this happened. Where are the nurses? I would argue to you, they are enthralled with the defendant. Ms. Grubb used that term in opening, enthralled. I had to look it up. It's not ENTH, it's different. Enthralled. It is a slavish devotion to someone. It is an unquestionable loyalty to someone. It is someone that you are captivated by and you don't question. That's what it means to be enthralled to someone. They knew where they trained. Cleveland Clinic, in their world, this world of medical professionals, that's like the Harvard and Yale of places to go. You go to Cleveland Clinic, you train at Cleveland Clinic, the best of the best. And isn't it interesting, ladies and gentlemen? That was a known thing. None of these other nurses knew where Dr. Hagris went to school in Maryland. None of these other nurses knew where the daytime people that they mentored them with. I don't know. They knew where Dr. Husel was. With Cleveland Clinic. They knew he was Doctor of the Year in 2014. His first year as a doctor. He's voted doctor. You'll see the certificate. He's got the piece of paper to prove it. And they all knew it. And they knew he was always willing to teach them. Here, come here, let me show you the settings on the vent. Let me show you how to do this. Let me show you how to put in an arterial line. Let me do this. They were enthralled to him. But what was their training and experience? For the most part, they were all very young and right out of nursing programs. Some of them went from like nothing in 13 months in the accelerated program to being on that floor a little over a year. And you're right into the nighttime ICU. Brand new. Some of them had prior experience in other sections, but like they told you, well, ICU is different. Each time you switch to a different thing, it's like you're brand new. You got to learn how they do things. So even with those nurses that had prior experience, they didn't have prior experience in the ICU. The more experienced nurses had just a few more years than the brand new ones.
Excuse me.
Remember the one charge nurse? How did you, well, I had about 2 years, maybe 3 years experience. Well, what did you have to do to be a charge nurse? I shadowed another charge nurse for 3 days. Now they're the charge nurse. So even the experienced nurses are new. And in schooling, they all testified when asked, yeah, you take a course, maybe an 8-week course, maybe a semester course on pharmacology, like you know what an opiate is, you know what benzodiazepine is. What about dosing? Learn all of that on the job. You learn all of that from other nurses and doctors and techs and everybody else you work with. That is something, when you start, you learn. And before I make this last point, ladies and gentlemen, I will say this, and I will argue this to you. They didn't sign up as new nurses in the ICU at Mount Carmel West because they wanted to be good nurses. They did this because they wanted to be great nurses. They wanted to be the best at what they did. This is a challenging place to work. And to get there right out of the bat. You're not sitting there just taking notes. You are in the mix, right there. Taking care of the sickest of the sick. Saving lives. Doing what you signed up for. They want to be great nurses. And here they've got this guy, the only guy there at night, teaching them, showing them bed settings. Other doctors don't do that. Showing them how he does procedures. Other doctors don't do that. I mean, if you ask, they'll explain what they're doing, but he teaches them. They are eager. They are motivated. This guy's Doctor of the Year, Cleveland Clinic training. He's teaching me. I'm brand new. They are enthralled to him. I would argue too they were unwitting complicitors in these deaths. They didn't know what they were doing when he ordered them to do this. But that's what was going on with the nursing staff, ladies and gentlemen. Count one, Joanne Belisari. Extensive medical records. I've just put up a little blurb about each one of them. Help you remember these folks in your mind. She was a 69-year-old woman. She was 4'9". She weighed 126 pounds. She has a seizure in April of 2015 at her home. It's witnessed by someone. It's all in the medical records. She gets to the hospital. They run some tests. They see this tumor on her lung. She might have cancer. She develops pneumonia, maybe from being in the hospital. She's intubated for respiratory failure. She's there for a while, the longest of all of our victims. On May 10th of 2015, on the defendant's order, she's given 1,000 micrograms of fentanyl. She is extubated and died within 17 minutes. Regardless of whether or not she was at the end of her life at that moment, ladies and gentlemen, she was dead within 17 minutes of that tube being pulled out of her throat because the defendant ordered her to be given 1,000 micrograms of fentanyl. A woman that needed a machine to live. Not 1 unit dose, not twice. Not twice, not 100% more than the unit dose. Not 3 times, not 4 times, not 5 times, not 6 times, not 7 times, not 8 times. 10 times the amount of what any other doctor would do in that situation. And she's dead in 17 minutes because of the actions of the defendant. Remember, the brother testified. It was important to him, it was important to his sister Joanne, it was important to his whole family. They're old school Catholics. We go to a Catholic hospital. That was the Catholic hospital in town. That's why we went there. My sister wanted a natural death. Nobody wants anyone to die in pain, but she wanted to go on her own terms in the divine's plan and their belief. They firmly believes, he told you. You didn't get that. He caused her death. He hastened her death, ladies and gentlemen. She might have been sick. She might have died anyways that night. But she wouldn't have died in 17 minutes. If you want to know if the doses are appropriate, and I've done this for each one of the 14, but you don't have these records yourself to look at. Look at, in the direct flows charting section, that's where you'll find pain scores. Of each of these medical records, they're all in the same place. There's the direct flow chart. Just flip right to it, find the pain scores, find when they've been in pain, and then go to the back. The last section of all of these records is the medication administration record. That is where you'll find the medications that were ordered and given. There's a section called orders, where the medications are ordered along with everything else. I would argue to you should look at the medication administration records, though, because many of those things that are in the orders section are PRN or are not actually given. If you want to know what was actually given, when you're looking at these medication records, look at the MARs, medication administration records. And look at the medication when she reports, for instance, she has a pain score of 7 on May 10th of 2015. At that time, at 1826. And look at the amount of hydromorphine Dilaudid that she was given to control that pain score of 7, 1 milligram. And that's Dr. Husel ordering that. So he knows. He knows what will control her pain. 7. Pain score of 7, a little bit of, he knows what he's doing, folks. This is an intentional thing. 0 pain, 0 pain. Extubation, pain score 10. Where does that number come from? Brian Hayes. Brian Hayes is a different type of victim than Joanne Belisari. Brian Hayes in count 2, ladies and gentlemen, he's one of the 2 overdose cases here. He's the one that's admitted in April of 2017 after being found unresponsive by his sister in the bathtub. Remember, Ryan, who had troubles, his sister knew about it, intravenous drug use, his adult life. She thought he was doing better. She was letting him live with her because his job was nearby and he could get there easily. They had gone out to a bar and had a couple drinks, didn't get hammered, it wasn't like some big night, a party. It was just kind of a night of just relaxing. He had to work in the morning. She doesn't have a shower, so he's going to take a bath, and she hears the water running. He's down for a while. He's down for a while. It's hard to say how long, but she calls the squad, she calls the police, they find drug paraphernalia. He's the one that had fentanyl, actually. Right? So he's not only using fentanyl out there, he's using the thing that's 100 times more, either wittingly or unwittingly, when he ingested those drugs out there on the street. And they're doing CPR all the way to the hospital. That's in the med report. They finally get him back right as they get to the ER. Dr. Ralston actually was his physician when he got there. One of Dr. Ralston's, they look at the medical reports. He's talking to the family. Ryan's on. The upper part of Ryan's brain, because they looked at the CT scan, they made a CT scan, and the images of the brain, you can tell he's the upper part, the part that perceives pain, the part that perceives emotion, the part that perceives anxiety, the part of what made Ryan is dead. It's gone. He's not legally dead or physically dead. You know this because even though he's on a ventilator, you'll see in the notes he's over-breathing. He's breathing on his own over that too. So remember Dr. Ralston explained to you. You got your upper part of your brain, that's the part of your personality, that's the part that makes you you. But you got this base primordial brain, whatever they call it, bottom part of your brain, that runs the autonomic parts of your body, the heart, the lungs, the breathing. That's still rolling. That's still rolling. The family's interested in organ donation. Read the notes. It's okay to wait. We can't harvest organs from a person who's not brain dead.
No, maybe he's not brain dead. But it's likely he's going to be brain dead in a few days. So it's fine to wait. Because he's not in any pain and he's not experiencing any anxiety. You tell him it's okay to wait. So the loop people come in, the organ donation people come in the next day. Ryan's body is not appropriate for organ donation, and the family decides to extubate him once his son gets there. Remember they said, it's very important to be at bedside. Lisa was at bedside. Was your brother exhibiting any signs of pain or anxiety? No, he was just lying there. He had a 0 pain score throughout his hospitalization, which corroborates everything Dr. Ralston testified to and put in his notes. Because no one is observing him in pain. He had no pain medications throughout his hospital stay. Because when Dr. Ralston says he's not incapable of receiving pain, that's true, corroborated by the fact that he had no pain. There it is in direct flow charting. 0 pain scores throughout the entire stay. That's it. Before we get to bed, ask yourselves this. What possible purpose could you have in ordering the medications Dr. Husel ordered to be given to Ryan Hayes other than to hasten his death or cause his death? Pain medication can be given to control pain. Anxiety medicine can be given to control anxiety. This guy didn't have it. Doesn't have it. And he doesn't start off small. He wallops him with 1,000 micrograms of fentanyl and 10 milligrams of hydromorphine. Remember, the equal analgesic dose of hydromorphine at Dilaudid? Times 10 again. Well, excuse me, times 100, because that's like another 1,000 micrograms. That's equal analgesic dose of 1,000 micrograms. So that's like equal analgesic dose of 2,000 micrograms. 1,000 of fentanyl, 10 of hydromorphine, and 10 of the benzo, all together. Bam, hits him with that. And out of nowhere, Troy Rudman, yeah, score of 10. I mean, it's out of nowhere, folks. What did the experts tell you? The people that have actually done this for years and years at other hospitals, at Vanderbilt and at Tampa, never seen that before. Never seen 0, 0, 0, 0, 0, 10, 10. Because no one else in the world does this. Ryan, possibly because he's a he uses carfentanil out on the street and fentanyl, doesn't die immediately from that dose. So 43 minutes later, hit him again. Another 1,000 micrograms of fentanyl, another 10 of the hydromorphine, another, it's either 8 or 10 of the benzodiazepine. And that does it. Dies a few minutes later. It is a crime to kill a dying man, folks. Ryan Hayes was dying. Part that made Ryan was gone. But his brainstem was still working. He's still over-breathing the vent when they did the palliative extubation. And the only reason to give him that amount of medication was to get him out of the ICU. Get it done. Beverly Schertzinger. She's 63, 5'4", 168 pounds. She went in October of 2017 because she had a coughing fit at night. She coughed so much, it's in the meds, she passed out, woke up, and her leg was hurting her. Her husband had died the year before from blood clots in his leg, and she's worried she might have blood clot because her legs hurt so much. So she goes to the hospital, has a neighbor drive her. There's no blood clot, but they find a mass in the lung, possibly cancer. Got to check that out. And then they, after some more tests, see some spots on her liver, possibly cancer. They do a biopsy on 10/9. Now, it turns out she does have cancer, but whenever you see these patients, these victims with cancer, They're not at the end of some long hospice stay. They're not at the end of some natural, long, drawn-out process. She hasn't even actually been diagnosed with cancer at this point. It's later confirmed. But what gets her? There's the biopsy. Remember Dr. Ely and Dr. Schertzinger talked about how much blood is in the liver? Well, they nick something in the liver. She's bleeding internally. They can fix her. That happens. Dr. Schertzinger even told you, yeah, that's a very common thing when you do a biopsy to cause some internal bleeding because the liver has so much of your blood coursing through it. They can fix her. Now, she's going to die of cancer. But Dr. Schertzinger told you, Dr. Schweiger told you, Dr. Schweiger told you, Dr. Ely told you, maybe not for another year or two. I mean, she had time. They just needed to fix the internal bleeding. But the family's called in, her son testified, nope, she doesn't have time. Your mom has no brain activity. That's what he told you. That's what he was told was going on with his mom. And what choice is that? Part of your mom, the major mom, is gone. She can either die here on the machine or she can die naturally. What kind of choice is that? They'd like to have her taken off. The mom that they've been talking to before this, I mean, she was awake talking to them in the hospital. And she dies within 10 minutes, never regaining consciousness. Because the defendant ordered that she be given 500 micrograms of fentanyl, which is 5 times the maximum dose that he should have been given, 4 milligrams of midazolam. It's nowhere in those records indicated that she would need this. Look at the direct flow charting. Look at the medication administration record. And when you're looking at the MARS, there's a section that is for things that are given all at once. The IVP pushes, that's in the first part. There is also, right after that section, infusions, which are the bags. Look at those two, because many of these patients, in addition to the medications that are in the MARS for pain, for the breakthrough pain, are also on continuous infusions, the drips, 25 micrograms an hour, 50 micrograms an hour, to get them to the baseline. So that's part of the story too. He doesn't order bags to be given to him during the act. He's ordering IVP pushes, boluses, all at once, 2 to 3 minutes, squirt it in them. And when you look at the pain she was in and how it was controlled before, there is no justification. What other purpose can you have in that type of escalation during that procedure with a woman whose liver is compromised, with a woman whose breathing is compromised, who is very sick, who is older? You don't give them more, you give them less. If your purpose is just to cover their pain and give them a peaceful, comfortable death. But if you're trying to move them along, as I would argue the defendant is doing here, you wall. What did Dr. Ely call it? Beyond thunderdome doses. Danny Millette, 74-year-old man, 5'6", 141 pounds. He originally goes to the hospital in November of 2017, and this is how it happened. He'd never been to his son said, I didn't think my dad had ever been to the hospital before November of 2017. It's because he stubbed his toe, like the month before, in his living room, on the carpet, got a little cut, it wouldn't heal. It got worse, and it got worse, and when he finally went to the doctor's like, go to the hospital now, this is terribly infected. And actually in November of 2017 had to amputate his toe and part of the other one. And he's not stable enough because he had part of his body amputated just to go straight home after that procedure, so they sent him to the nursing home, where after a week or so there, he becomes unresponsive, things aren't right with him, they don't know what, he's hallucinating, so he goes back to the hospital. His son Brian testified, yeah, I called my dad every day, and when I couldn't get a hold of him, I got a hold of my mom, we're on our way there. So after his stay at the nursing home, he's back on 12/5. He goes by squad to the hospital. He does code 3 times in the hospital. And that day, on defendant's order, he's given 1,000 micrograms of fentanyl, 4 milligrams of midazolam, 2 milligrams of hydromorphine. He's extubated and dies within 18 minutes. The family was told, yeah, your dad has brain damage. You can either stay on the machine and die, or you can let him die naturally. What choice is the family really being given? What good information is the family really being given? What did Dr. Schweiger say the standard is in the ICU? You have to wait for the patient to pronounce themselves. Even folks that code several times. And remember, he's coding in the hospital, so it's not like Ryan who's down in the tub for who knows how long without CPR. He's in the hospital coding. And while that is very serious and can cause a lot of damage, he's got the best care, you know? They're doing CPR, they've got them lined up, they're giving them the right drugs, they've got the crash carts there. Patients will surprise you. You have to give them time to let you know where they're at. Time Danny Millette didn't get. Because of what the family was told, because of the drugs that were administered to him upon his extubation. The only other pain medication he was given during this stay was Tylenol, and that was as needed. Doesn't even very bad. 0 pain scores. Jacob Deemer, score of 10. Remember Greg Dreschbaugh's email? Seems like we have some same characters involved in these. Brandy McDonald, 37 years old, 5'7", 280 pounds. She was a cancer patient. She had beat ovarian cancer a number of years before. It had gone into remission, and it came back. And she's at the Zengmeister Center being an experimental immunotherapy. And she's at a doctor's appointment, and they run some tests, and they're like, we don't like your liver enzymes. You've got these other comorbidities. You've got diabetes, you've got these other things. We want you to go to the hospital, and we want you to be monitored at the hospital so that we can carefully see what's going on with you. So yeah, she has cancer again. Yeah, she's getting this experimental treatment, but she is not a hospice patient at the end of a prolonged death. Calls her mom. Mom, can you take me to the hospital? Okay. They drive from London, get her to the hospital. They park in the parking garage. They walk in. This is not somebody that is on death's door when she goes to the hospital that day. She was in no distress. She was not dying of cancer at that point. Mom, her partner, Dan Ripley, they went and had coffee last time they saw him. Do you want me to spend the night? No. No, the weather's bad, Mom. Go home. I'm fine. That night, she develops severe acidosis. She's intubated and transferred to the ICU. Family's called. It's over. It's done. You can either let her die on the machine or let her die naturally. Well, they didn't want Brandy to live for the rest of her life on a ventilator. That was the choice they were given. Had Brandy pronounced herself? Had Brandy been given all the options? Were her cancer doctors at the Zengmeister Center called and consulted? Were the doctors that had been treating her for the several days called and said, hey, this is what's going on with her? No. Nighttime, ICU, family's told, do you want her to live the rest of her life on the ventilator, or do you want her to let her, pull the plug and go natural? And who knows if she ever would have woken up, because she was given, on the defendant's order, 1,000 micrograms of fentanyl, 6 milligrams of midazolam, extubated and dies in 5 minutes. Look at the pain scores from the hospital stay. Look at what was given to her to help her control any pain she might have been in. And ask yourselves, what was the purpose of these medications at the time of extubation? Frances Burke was 73. She's 5'3", 215
Okay.
pounds.
Mr. Zion, hold on. We've been an hour and a half. How you all holding up? Do you need a break, guys? Okay. Let's take 10 minutes enough? Okay. With it, David, call it up.
All rise.
Remember the admonitions and do not discuss the case yet. You don't have the law.
I changed that, so.
Just wanted to make sure. So this is the one.
No, she did not. This is what happened to her. I checked it in the, let's go pull the records, let's go look at it.
Well, wait.
Okay. Be seated.
Oh,
Yeah, so there were just
Okay.
little things there.
all right, yeah,
So
change
I
that.
didn't
Okay,
hear
yeah, go ahead
more.
and make those changes.
Okay.
No, I did change that one back then. Did the,
Okay. Mr. Zion, I'm guessing you'll probably go till noon by the time you're done.
probably. I mean, I'm just going to go through the rest of the patients and records and then, and then I have some closing remarks, but yeah, I mean, probably close.
Okay. Mr. Baez, I assume you'd prefer to start after lunch and get into 3 or 4 minutes of your argument?
If it's 3 or 4 minutes, obviously not, but if I have a half hour, I'd like to
Okay.
take.
I just getting a barometer because I always hated breaking them up if I could avoid it.
Understood.
Okay? So let's play it here. Anything for the record, Mr. Zion?
No, sir.
Anything, Mr. Baez?
No, sir.
Okay, enjoy your 10 minutes.
All right, yeah, I did not change it. I mean, I just pulled the one and worked on it over the weekend, and it was on the K drive, so.
Yeah, I don't know how.